Welcome to the High Court Report. It's nice to be back after a short hiatus. How's your holiday going? I enjoyed spending time with my family in Virginia, Maryland, and New York. While I couldn't focus on creating new content, I was constantly brainstorming avenues for growth and improvement. I spent a lot of time working under the hood. I'm trying to make this setup technology driven, one, because I enjoy technology, and two, because I want to grow and scale. I spent some time vibe coding. For example, I'm trying to write a script that'll count and decipher the number of amicus briefs and run some basic reports on them. I also just wrote coding scripts that, one, create automated reports when the Supreme Court takes on new cases, two, download the merits briefs or flags if they can't for all new cases, and three, gives me statistics on the current number and types of cases. I'm also trying as a long-term project to figure out a way to better warehouse my Supreme Court data so that I can quickly look up and rattle off all sorts of stats, insights, and trends for you. But my current system can't do that well. I'll tell you more about that later. Now, for some of these updates, you won't notice anything until the summertime when they go live. I just started planting some of the seeds now, and I plan to take incremental steps until we get to the summer. But one area you'll notice right away, I'm test driving a new format for my case summaries. I'm always tweaking the case summaries, so tell me what you think about them. Oh, and how do I sound? A gracious family member got me a podcast microphone for Christmas. Thank you so much. Now, I had a chance to prepare summaries for the January cases. You're gonna love them. We have hot button issues, one after the other. For example, a Second Amendment case, a showdown over Trump's firing of a Fed board member, and a challenge to a law that requires people to play in the sports of their biological sex, regardless of their transgender status and gender identity. Here's the roadmap for today. I'll talk about 2 emergency docket rulings, and then I will briefly run through the January slate of cases. As far as a podcast posting schedule goes, after today, I'll begin to post case summaries, and then on Friday, January 9th, I'll hold a mega episode where I talk through all of the cases that we just summarized. That following Monday, January 12th, Supreme Court oral arguments begin again. As you can see, things are heating up. Tune in to all the action by following us on Apple, Spotify, YouTube, and wherever you podcast. Also, reach out via email, scotus.cases.pod@gmail.com or LinkedIn. Okay, we're done with the housekeeping. Let's listen to the episode.
You know that feeling when your neighborhood gets dangerous and you wonder if you should call for backup? Now imagine you're a federal agent trying to do your job and someone puts a $10,000 bounty on your head. That's basically what happened to federal immigration officers in Chicago. And when the president tried to send in the National Guard to protect them, the Supreme Court said, not so fast. Today we're diving into Trump versus Illinois, a case about when presidents can deploy military forces on American streets. We'll also talk about Margolin versus National Association of Immigration Judges, both cases where the court issued emergency docket orders.
For Trump versus Illinois, the stakes go way beyond Chicago. This redefines presidential emergency powers for the first time in nearly 200 years. Federal agents attacked in pre-planned ambushes, violent mobs blocking government facilities, and Texas National Guard troops sent to Chicago over Illinois' objection. Plus, the Supreme Court handed down this decision on December 23rd, 2 days before Christmas. Before we go further, quick reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Questions? Reach out to us via email LinkedIn at the High Court Report.
Back to Illinois. The case asks whether president can federalize the National Guard under 10 U.S.C. Section 12,406 to protect federal immigration officers from violent attacks when regular law enforcement can't handle it.
The statute says the president can call up the Guard when he cannot execute the laws of the United States with the regular forces.
The $64,000 question: what counts as regular forces?
The government said it means civilian law enforcement, ICE agents, FBI, federal marshals. Illinois argued it means the regular military, Army, Navy, Marines.
If regular forces means the military, then the president first needs authority to use the military for law enforcement, which the Posse Comitatus Act generally prohibits, before calling up the Guard.
Let's rewind. Summer 2025. Federal Immigration Enforcement launches Operation Midway Blitz in Chicago. Within weeks, they arrest over 800 people, including what DHS calls worst of the worst criminals. Federal officers face what officials describe as a harrowing, pre-planned ambush involving many assailants. Attackers ram government vehicles, shoot fireworks and improvise weapons at agents, and repeatedly block access to the ICE facility in Broadview. Someone posts a $10,000 bounty for murdering a senior federal official.
Local police either can't or won't help. Federal agents call for backup during life-threatening attacks, and Chicago PD shows up late or not at all. By October 4th, President Trump decides enough is enough. He invokes Section 12,406 to federalize 300 Illinois National Guard members. Then he adds 400 Texas Guard members for good measure, against Illinois' explicit objection.
Illinois and Chicago immediately sue. October 5th, the very next day, they run to federal court claiming the president exceeded his authority. The Northern District of Illinois grants a temporary restraining order on October 9th. The Seventh Circuit splits the baby. They say the president can federalize the Guard, but can't deploy them to Illinois.
The government races to the Supreme Court. They file an emergency application on October 17th. 2 months later, December 23rd, the court denies the stay. The government's first argument channels Andrew Jackson. The president's military decisions deserve absolute deference. They relied on Martin v. Mott from 1827, where the court said the president's determination about military emergencies belongs exclusively to the president.
Illinois fired back. That case involved calling up militia for actual war, not using the Guard as backup police. They argued courts can review whether statutory prerequisites exist.
On regular forces interpretation, the government insisted it means civilian law enforcement. Illinois pointed to the statute's history. When Congress wrote this in 1792, regular forces meant the standing army.
They sided with Illinois on every major point. The court said regular forces means military, not civilian law enforcement. They rejected the government's argument about absolute presidential deference.
No more National Guard deployments like this unless the president can first justify using the military under another statute. The court said, if you want to deploy troops domestically, follow the proper procedures Congress established.
Let's move next to Margolin, a potential constitutional crisis hiding in plain sight. Immigration judges, the people who decide whether someone stays in America or gets deported, just scored a massive victory against their own government.
The case goes by Margolin versus the National Association of Immigration Judges. Darren Margolin appears as the applicant, but he actually runs the very agency that imposed the speech restrictions the judges are fighting.
The government sued using the name of the guy enforcing the policy, like the principal filing papers on behalf of the school board, while students protest the dress code the principal created.
These judges wanted to speak publicly about problems in the immigration system. Think overcrowded courts, impossible caseloads, broken technology. But the Executive Office for Immigration Review slapped what constitutional lawyers call a prior restraint on their speech.
Prior restraints represent the nuclear option of First Amendment violations. Courts typically reserve them for preventing immediate violence or protecting national security secrets.
The government argued, these judges work for us as federal employees. So they must use our internal complaint process instead of suing us in federal court.
Except evidence emerged suggesting the government corrupted its own complaint system through political interference. The Fourth Circuit started asking, how can you force people to use a process you potentially rigged? The court worried about regression to the 19th century spoil system where political loyalty mattered more than merit. They ordered factual investigation into whether outside officials interfere with the Office of Special Counsel and Merit Systems Protection Board. The Supreme Court denied the government's stay on December 19th, but included specific conditions and cited Cheney versus United States District Court, creating what I call a discovery escape hatch.
Federal Judge Rebecca Beach Smith in Virginia gets to investigate the slowest bureaucratic processes in government. The immigration judges can now demand documents, take depositions, and ask pointed questions about whether their complaints get buried for political reasons. This affects 2 million federal workers. If this case succeeds, employees across government might bypass internal processes and flood federal courts with lawsuits. Immigration judges can't discuss the immigration crisis while they decide cases daily. It's like preventing emergency room doctors from discussing a pandemic while treating patients.
Before we wrap up completely, I need to give our listeners a taste of what awaits in January. We're looking at constitutional blockbusters that could reshape American law for the next 30 years. Second Amendment meets property rights. Transgender athletics meets Title IX. Federal power meets state sovereignty. Little versus Hecox brings us the transgender sports battle everyone's watching. Can Idaho ban transgender women from women's athletics? Lindsay Hecox literally tried to dismiss her own case 3 months before. Supreme Court arguments. The district judge said, absolutely not.
Wolford versus Lopez turns Hawaii into the Second Amendment battleground. After Bruin struck down Hawaii's gun laws, the state fired back with an express permission requirement. Want to carry your legally owned firearm into a store? Better get written permission first.
CSX Galette versus NJ Transit Corp. determines whether massive state corporations can escape lawsuits by claiming sovereign immunity. Picture getting hit by a state-run bus, then being told you can't sue because they're technically the state.
M&K Employee Solutions versus IAM National Pension Fund. 4 companies withdrew from a pension plan and suddenly owed millions more because an actuary changed assumptions 3 weeks too late. A tiny timing change that tripled their liability from $1.8 million to $6.2 million.
Trump versus Cook. The president fired Federal Reserve Governor Lisa Cook for allegedly lying on mortgage applications. This asks whether presidents can reshape independent agencies through aggressive for-cause removals.
Chevron USA versus Plaquemines Parish. Oil companies that fueled World War II fighter planes now face $744.6 million in state court verdicts for 80-year-old production methods.
These 6 cases touch Second Amendment rights, transgender equality, executive authority, sovereign immunity, pension law, and environmental accountability.
We'll preview each of these cases, plus full coverage of oral arguments and eventual decisions. These cases will reshape how Americans experience constitutional rights in their daily lives.
That's a wrap on today's High Court Report. Remember to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you listen. Follow us on LinkedIn for nearly daily updates and YouTube for shorts. Questions about today's cases? Hit us up on LinkedIn. Thanks for listening, everyone. Talk to you soon.